is that he does. Mr. Gordon was a broadcaster himself and a fighter himself, and he has quite an extensive library of fights on tape. I believe...
Personal library, is that what you're telling me?
I don't know, Your Honor. We don't know why he requested that.
All right, that's neither here nor there.
So to go from saying he requested it to start an official investigation is quite a leap, which I think if counsel wants to prove that, he should do that by calling Randy Gordon. He can't do that through this particular witness, because anything that this witness has to say would necessarily be
Is that
hearsay.
this witness has got, that there's a hearsay objection here, correct? Right? As well as irrelevant.
Well, that was proffered testimony that took place outside of the presence of the jury, but in the courtroom in the meantime, the jury is coming in, and we expect to have closing arguments. Let's go into the courtroom.
This is the stage of the trial in which the lawyers make their closing arguments. It is their last opportunity to speak to you, to summarize the evidence from their point of view, and to make such arguments to you as they feel are appropriate from that evidence. The order of proof, in a sense, is reversed only in that the defense goes first in their closing argument, and the prosecutor, who bears the burden of proof, goes last. We will begin with defense closing argument.
On behalf of Mr. Mercer and his family, let me start out by saying thank you. We appreciate the time and effort that you've put into the case. From our vantage point, you've been attentive to the evidence as it's come in, and it's with that same attentiveness that I'd ask you to listen to my remarks now, members of the jury, because obviously this is very important for Mr. Mercer. My purpose, as the judge just indicated, is to comment on the evidence and the lack of evidence in the case, and to make arguments from it. During the course of that, I'm going to be talking about the facts that came in, the evidence that came in. Now, your recollection of that controls. If something I say is inconsistent with something that you recall collectively in the case, obviously you're to rely on your own recollection. But I've attempted to prepare these remarks carefully. Further, I will be not talking at all about the law in the case. As Judge Atlas has made clear repeatedly, he is the final arbiter with respect to the law. I am going to be talking to you about the facts as we see them from Mr. Mercer's perspective, and as I suggest, the same facts that you shall find in this case. The investigation and the prosecution of this case, members of the jury, has been a combination of unreliability, unfairness, and perjury. From the tape recording that was admitted into evidence, the so-called beta original tape, to the transcript that was identified as allegedly reflecting what was on that tape, to the testimony of Ferguson, this case amounts to a frightening failure of proof. Absolutely frightening that on the basis of this proof, Mr. Mercer stands here to be judged. Let me start from the beginning. February 6, 1993. After the fight, nobody made any complaints at all about what occurred. Not the referee, not the judges, not all of the HBO people that were in the ring and around the ring and in the control room. Nobody made any complaints about it. Not a single soul. You remember when referee Kelly was on the witness stand, he said the judges were so close to the fighters at times when they were by the ropes, that the sweat actually, on occasion, would hit the judges. That's how close the judges were to the fighters in this case, while these people were allegedly talking according to the prosecution. Not a single person made a complaint. The referee made no complaint. HBO made no complaint. Now, HBO, these are the people who are listening, talking about the people in the control room with the sound. They're listening to what's happening as it is occurring. Like this man right here is listening to the sound occurring in the courtroom. That person, whoever it was, did not come here to say, oh yes, I heard something. This is an original tape. I can identify this, etc. We didn't have any proof like that in this case because nobody made a complaint at the time. And even if a complaint was not made at the time, still, they could have called these people to testify on their case. It's their burden to prove that Mr. Mercer is guilty here. Nobody was called here, not a soul except Mr. Ferguson. Consider HBO's motive, too, at the time. Can you imagine how much good publicity HBO would have gotten to break this story? In other words, they're a semi-news entertainment organization. It would have been great for them to come public with this story. There's a lot of notoriety involved in this case. The reason that HBO didn't do anything about this at the time, with their directors and their technicians in the ring and their cameramen and their sound people and their tape operators, is because nothing happened which was extraordinary or abnormal in that fight. Mr. Mercer is not guilty. You would have to acquit Mr. Mercer in this case, even if he were guilty, if the proof against him failed. In other words, their obligation is to prove guilt beyond a reasonable doubt. Even if he were guilty, you would be obligated to find him not guilty if the proof failed and it didn't show he was guilty. This is not that situation. This situation, this man is innocent of this charge. He's not guilty at all. When did this start? We know from the proof it started in March of 1993. That's when this investigation started. How did it start? We heard again today through Officer Weiss. It started through this fellow, Randy Gordon, in March of 1993. Now, remember in the opening I told you, watch the critical period between the fight on February 6th and the time that this investigation begins in March of 1993, about a month later? That's a critical period of time. And you heard what Greenberg said, Mr. Stephen Greenberg from HBO, when he was on the witness stand. He said that a couple of days after the fight, Gordon called him and wanted to get a copy of the fight, according to Greenberg, the line copy clean. Remember now, Gordon does not begin an investigation until a month later. His assistant, who was on the witness stand today, found out about the allegation the end of February, just before the announcement was made. So what is going on in this 1 month period? What is Gordon interested in this one month period, members of the jury? Now let me just read to you from Greenberg's testimony to make sure you know that what I'm saying is accurate. Question: the fight occurred on February 6th of 1993. Within 2 or 3 days, Randy Gordon called you on the telephone and asked you for a copy of the line copy clean, correct? Answer: correct. Now, what is he doing there? What is he interested in there for? Now, remember, what happens in March, this thing gets a lot of publicity. I refresh your recollection by saying, you remember Ferguson? He said that he was interviewed by CNN when he said that Mercer was innocent. That was on March 3rd. There's a lot of publicity and fame and infamy involved in this case. Publicity is valuable, members of the jury. It's valuable to people. Fame is valuable It translates into money. It translates into other things. Gordon's got an investigation. CNN is involved. Gordon is conducting the investigation. He brings in the state police. Well, let's look to this Gordon. You remember also when they indicted Mercer. When Ray Mercer was indicted, you remember Talor said there was a lot of publicity then. There were cameras and everybody got on television at that time, including Mr. Gordon. And what am I saying here? I'm saying here that there was impropriety in this case with respect to that tape recording from the very beginning in this matter. Remember, it's not our obligation here to prove, members of the jury, that the tape is a phony. It's their obligation to prove it is authentic. But we have proven that tape is a phony. Now, the only evidence in the case that anybody was concerned about the fight immediately following the fight comes from, guess who? Jesse Ferguson. He says, after the fight, I went back in the room, not on TV, not during the fight, not on camera, and I told my manager, Cohn, what had occurred in secret. I submit what he was doing there, and this is an awful deal, but it was happening here. He was secretly justifying what Randy Gordon was supposed to be doing right after the fight. That was going on there. Now, as Ferguson was giving an explanation for Gordon to say, well, Gordon, and a couple of days after the fight, Gordon was looking, he was concerned. He was looking at this thing. He must have heard a rumor about it, based on what Ferguson said. That's going on here. Now, Ferguson, where's the corroboration of that? Ferguson doesn't talk to his corner during the fight, he admits. Where's the corroboration that after the fight, he went to talk to his manager, Cohn and Braunstein? Why didn't they put them on the witness stand about that? To say that Ferguson really did in fact say that. That's totally uncorroborated. But it gives a basis for Gordon's crew. It gives a basis for somebody to suggest, well, the reason that Gordon was looking for a copy of the original tape within 2 days after the fight, even though nobody made any complaints, was the reason was he had heard something. There was some rumor that must have gotten to Gordon through Ferguson telling his manager. And that must have gotten to Gordon, and Gordon was going over to make a good faith inquiry. Ferguson didn't say that at all to his corner. They didn't corroborate that. That could have been corroborated by the people, Cohn and Braunstein, and other people who were with Ferguson. That didn't happen. Gordon did not begin an investigation here until March, a month later. If he had gotten wind of what Ferguson was saying, say Ferguson, for purposes of argument, really did say that awful thing that night, and Gordon found out about it, what would Gordon have done? He would have begun an investigation at that time and announced it and brought in the state police, right? He didn't do that. He waited a month. Now, is the tape phony? Admitted today into evidence were 2 letters from HBO, the lawyer who was in charge of responding to the subpoena. She says in her letters, which she executed at the time, which she submitted to the prosecutor at the time, that the original line copy clean in this case was not a beta at all. It was a 1-inch reel. It was a 1-inch reel. She says she has no personal knowledge about it, but that's what she believed at the time. Now, what if it was? What if she's right in her letter? What if she did an investigation at the time? What if she's right and the original tape in this case of the Mercer-Ferguson fight, the original line copy clean, was on a 1-inch reel? Is that frightening? That means necessarily that the beta tape introduced into evidence is not authentic. That's what that means. It's a very frightening thought, and it's actually true, as I'm going to show you in a few minutes. Not only was she right when she said that, talking about now the original the original line copy clean on Mercer Ferguson, she says in this letter was a 1-inch reel, and in this letter 2 days later, she says the original line copy clean with Doak's bow was a 1-inch reel. That's consistent with the rehearsal tape being used later. Both are 1-inch reel. That's what's going on in this case. That's when I say to you, go back to what Gordon was doing, looking for the copy of an original 2 days afterwards. There was a switch made here with respect to this. This explains, members of the jury, why the tape operator, the person who was making the tape, right? There's a human being out there making that tape. Why he did not testify. Look, I have no burden here. That's the law. The burden lies on the prosecution, members of the jury, to prove this case, to prove that the tape was authentic. I have no burden to start calling people up and putting them on the witness stand. I mean, is it fair to say, is it reasonable to say that they should have authenticated the tape by bringing in the tape operator? I mean, is that an unreasonable thing? You make the calls here. The judge is going to tell you what reasonable doubt is, where reasonable problems, that is, we have reasonable questions about going forward and finding this man guilty. Is it unreasonable for me to say to you, why didn't the tape operator come here to identify that tape? There was no mystery during this trial that we were questioning the authenticity of the tape, both with respect to my questioning of Mr. Greenberg and Mr. Barrett's questioning of Ms. Johansson. We were all over this issue. Greenberg testified that the librarian in HBO keeps detailed records matching numbers to original tapes, right? I asked him, you may recall, are those logs available? Are they available, showing that the numbers on this particular tape match there? He says, yes, they're available. We didn't see any logs. We didn't see any librarian come in here. We didn't see anybody come here saying that I put this original label on a specific tape. Now, is it unreasonable for me to say that to you? Have I been surprising anybody with respect to the position here? That this tape has not been properly authentic? And consider this in the context of this fella Gordon, 2 days after this event, going there and seeking a copy. You know what Johansson said in the record here? Judy Johansson, the duplicating person? She said the first copy she made was in March. That's in the testimony. She never saw it in March. What was copied? Who copied it? Where was the original on March 8th, or pardon me, on February 8th and February 9th? That's all in the record. Where is it? Who copied it? It wasn't her. Who got the original? In the meantime, it's a coincidence that she's writing here that the original was a 1-inch. I mean, is all this a coincidence? One thing after another? The failure of chain of custody. You remember when Mr. Contos was in the witness stand? The prosecutor went through a meticulous examination on the direct concerning who had the tape after July. The tape went from here, it was sealed here, it went there. The chicken here was killed early, right? Not in July. It was back in February. It was February. It was before Gordon made this announcement that there was an investigation, before they went to Ferguson. That's what happened here. It's all over the place, the proof of it. It's not only an issue, members of the jury, that you should doubt the authenticity of that exhibit. It's a phony. according to their own letters. Now, of course, Ms. Patrick goes on the witness stand today and says, well, I don't really know the facts, but I understand now I'm mistaken. The lawyer, I understand now I'm mistaken with respect to it. Here's what Greenberg said on his testimony. First of all, he said there were 6 tapes made that night. Not 5, 6. One is missing here, even according to his testimony. Secondly, he never saw any tapes. That wasn't his job. He was testifying to what he called was standard operating procedure. Importantly, he said that until 1 year ago, they were using 1-inch tapes to do their line copy cleans. And prior to that was always a 1-inch tape. He said only in the last year have we switched to beta. And he didn't see anything. The first time he saw the beta was a few days ago. Here's what he says at page 221 of the record. That changed about a year ago. Answer, yes. Prior to that you used. Answer, prior to that we used 1-inch. Well, when he was on the witness stand, it was in March. 1 year ago is March of 1993. The fight occurred in February, members of the jury, not in March, February. Even his testimony suggests that the original line copy clean here was a 1-inch, like Ms. Patrick said, and not a beta. He also said, and this is quite important, that there should have been 5 other originals besides the line copy clean. And all of those 5 were recording what was going on during the course of the fight. They were all here, and then 4 of them allegedly are in evidence, and there's 1 missing. Now, nobody has played any of those. Now, what did he say about those? Remember, the line copy clean is being made from, and at the same time that those other tapes are being made. Mr. Greenberg gave very specific testimony about what was on those tapes. The fight was supposed to be on those tapes. The Mercer-Ferguson fight. They were using them for purposes of doing the slow motion to go on to the line copy clean. Let me read this to you because it's important. Well, I won't read it to you. You can, of course, ask for it. Let me summarize it for you, but I have the record right in front of me. He said that during the course of the fight, the director or the person in charge would tell the tape operators what slow motion he wanted to go to put on the line copy clean. And the operator would go to that portion, give it to the director, and then the operator would go back to the end of the round, for instance, end of the first round. But that first round would be intact in the usual situation. He said usually. He didn't say this happened 100% of the time. He said this is the way it usually happened. So at the end of the first round, on the tape, the second round would immediately begin. The intermission period of 1 minute would be taken out, and so on. So that when you look at those original tapes or copies of them, which could have been made available to you but were not, you will see the first round, then you will see a cut. You will go immediately to the second round, immediately to the third round, and so on. All that's different sound. That's all the different cameras, all the different mics. And the issue here is not the camera, not the photography. The issue here is the sound, But all that stuff, according to his testimony, would usually be available on these other tapes. Usually available. None of it's been played. There's been testimony, though, about it. I asked Investigator Talor whether he was aware whether rounds 1 through 5 on one of those tapes had been erased. I asked him that, and he said, I vaguely remember that. I vaguely remember. Now, here's the man who is part and parcel of the prosecution team saying, I vaguely remember. Now, remember, we got a line copy clean, but we got 5 other tapes as source material for this investigation. They would have been all over that stuff, studying it. He claims he vaguely remembers that rounds 1 through 5 were erased on one of them. now members of the jury, it was his job to do it. He knew exactly that rounds 1 through 5 were erased and that the other tapes have no evidence of wrongdoing here by Mercer in connection with this case. This is the same man, Talor, who came on the witness stand and said that he did not prepare the prior transcript. You remember? He said, well, it's not the same as mine, but I didn't prepare it. And his boss, a few minutes ago, testified that he did. Talor said that the first transcript that he prepared was recently, in February. And I asked him, there's a prior transcript, isn't there? He said, yes. Did you prepare it? No. His boss said today in June, Talor prepared it. That's the mentality that has led to Mr. Mercer's indictment in this case. That's how frightening this is. Now remember, with respect to the other tapes, I'm going to anticipate something that the prosecutor might say. You know, oh, maybe the announcers were on the other tapes too. Well, we know, according to this proof in this case, that the announcers have been removed from this. You can remove the announcers. Greenberg said usually you would have the entire fight. Usually, and they've done nothing about it. That's his testimony, usually. Well, the entire fight usually is on there, but you haven't seen anything. It's their burden here. Now, Ms. Johansson, what did she say? She also did not see any original tape, that original beta, until her testimony is May of '93. She said that the first time she duplicated it, she didn't see anything in March. That was the first request she got, in March. She also identified a memo. This is after this beta was turned over to the prosecutor. She calls all the reels, she calls all the tapes reels. Dubs were reported of these 5 reels, and now are in file. Members of the jury, a beta is a cassette. It is not a reel. They didn't produce anybody here who claimed to have personal knowledge of it. Not the librarian, not the tape operator. Everything was standard operating procedure. Standard operating procedure. The prosecutor will say, well, Mr. Amorosa had the beta looked at by an expert. It's not my burden here, members of the jury, to prove this man is innocent. It's their burden to prove that he's guilty. It's their burden to prove that tape was authentic. It's their burden to explain what was happening here as it was happening, because this is no surprise that these issues are in this case. Do you remember this so-called beta original has this expression, TBA, to be announced? Well, you know from a document in evidence, members of the jury, that the Ferguson fight was signed. Ferguson signed his contract in January 7th, 1 full month before this fight. Yet that label on People's Exhibit 3A, I believe, has to be announced on it. You remember also that Ms. Johansson said that other departments besides her department called for these originals, wanted to make copies of them, had the ability to withdraw, wanted to use the original for source material. None of that has been established in terms of the chain of custody here. Who had the tape and when? Through whose hands did it go? And you know who further proves that this tape is a phony? Ferguson. And he proves it very specifically. He calls it a lie. Page 760 of the record. To Mr. Ferguson on the cross-examination. The question is, you don't even know for a fact yourself that this tape is genuine. You're relying on what the prosecutor told you about whether it's genuine or authentic, correct? Answer, yes. Question, in fact, if the tape has on it a statement by you, quote, "You don't have any money for me," end quote, that tape is not authentic. Is that correct? Answer, yes. Going to page 759 of the record, again on the cross-examination of Mr. Ferguson. Question, I want to make sure